decision making. Section 20. I don't want to labour Section 20 because it could, we could spend hours and hours on the subject alone. And but there's just 2 points that I was going to make on that, and that is ensuring that your managing agent does follow the consultation procedures and that you understand them as well. Section 20.
I've never heard of Section 20.
Right. Okay. Section 20 is part of the 1985 Landlord and Tenant Act and latterly the 2002 Common Home and Leasehold Reform Act. And what it is, in the terms of consultation, it sets limits on expenditure of the manager and the rights of recovery from the leaseholders of such expenditure. So, for instance, that limit on qualifying work, so building repairs and maintenance, is £250 before the managing agent or manager has to consult with the leaseholders. So, for instance, if you're redecorating a block of apartments, if your individual contribution was going to exceed £250, then the landlord or manager is obliged to consult with you. And if he doesn't consult with you, then the expenditure is at his risk. So, where I was coming from on with Section 20, it's just so as leaseholders you're aware of that and how important it is, but also not to put pressure if you're an RMC director or RA chair that wants works pushing through as quickly as possible, but not to bypass the process and give instructions to your managing agent to do so, because things will come back to bite you. And we have a small development at present where there was a breach of Section 20 and the liability to consult wasn't thought through well enough. And the RMC directors, the only small development, they held an AGM, agreed to a programme of works, and instructed the managing agent to proceed with these major works. And it exceeded this £250 per resident. But because they agreed the works at the AGM, they felt they didn't need to go any further with the statutory consultation. It just so happens that further down the line, one of these leaseholders doesn't want to pay service charges, and it's a standard arrears case has been transferred from the county court to the LVT, or the first tier tribunal now, and they're now looking at this. And regardless of whether or not the resident management company directors agreed the expenditure in advance, they did not follow Section 20, and it now means in all likelihood that there'll be a debt to the resident management company because these costs couldn't be recovered from this one leaseholder. And it's where that could lead the RMC, because the RMC generally don't have assets, and this bad debt put back into the development potentially could bankrupt that development. So it's just to make sure that as resident management company directors and leaseholders that you understand often why there is a delay maybe in works being progressed. You have to consult for 30 days with for the first notice of intention, then there's a tender process, another notice of 30 days. So often it can be 3 months or more from planning to do major works projects to actually the contractor starting. So Jerry, yes?
It's a Section 20 question.
Yeah.
We're in that situation where I live for the first time in 5 years of running our estate, because we have a major works programme to replace all our entrance doors, and we believe that it will come over the £250. Even though this will take us, it will happen within the budget. We're not going to raise any extra service charge revenue from people to do it. It will take us 3 years to do it, and we're in separate blocks. We have 13 separate blocks, not just one building. We have 58 entrance doors to replace with all the accoutrements. It's a big task. People have been questioning whether, because we're in separate blocks, you need to have a Section 20 for each block, whether we do the whole estate, whether it still applies because it goes over a 3-year programme. What would you say about it? Because it's not just as clear as it might appear at first.
I'd say this is one for Sian. Yeah.
depending on whether you consult for the whole estate or for individual blocks, depends on the terms of your lease, and I haven't seen your city key lease, so you'd need to get some advice on that. With regards to Section 20, there's been a case that's currently going to appeal, which has put a real worry with all managing agents and landlords in general with this £250 rule. The story is that it was for a holiday park down in the south. It was new owners, and the new owners said to all the chalet owners in this holiday park, we're going to completely revamp this holiday park, this is how much we're going to spend on it, but they didn't go through the formal consultation process. And then, lo and behold, the holiday owners or chalet owners were very happy with this works, but they weren't happy with the £8,000 bill that they received at the end of it. Disputed it because they then said, well, we haven't actually, landlord, we're not paying you this because you haven't consulted properly, but we're really enjoying these works. And what the appeals court said in that particular case is it's not just £250 per item. The test is, which I think is wrong, but currently the test is it's £250 per year for all works, which would be an absolute nightmare. But that is the current rule at the moment. But it's currently going to appeal. Now, from a legal point of view, we all think that decision was wrong, and hopefully it will be overturned on appeal. But as it stands at the moment, this case specifically says you have to consult on everything if all your works will actually cost you more than £250 per year, which obviously is always going to be the case, which is absolutely ridiculous. But that's the current situation. So going back to you talking about, well, it's all going to be within budget, that doesn't matter, we will still need to consult. And certainly there is a concern. I mean, I've asked a lot of professional landlords and also housing associations, and so I've been giving a lot of training over the last 12 months to everyone at landlord level to say, what this is the situation at the moment, and this is the risk if this case doesn't go the way that we want it to. And I spoke to 60 different housing association people at a national conference in December, and no landlord had actually put any new provisions in place. I think everyone's just hoping this case is going to be overturned. But certainly at the moment, you've got to consult.
Yeah.
The issue will be whether you consult per block for the cost, or whether your lease says you consult for the whole of the estate, and I don't know, you have to specifically look at that.
Thank you, Thomas.
Just, is there a distinction between these qualifying repairs and regular maintenance work that's done on a schedule? Because most things will probably be budgeted as a regular maintenance, reoccurring maintenance.
Well, it depends as well, because there's two ways that you look at the works that are subject to Section 20 consultation. You could have a long-term qualifying agreement, and that could be, for example, a lift contract, or it could be garden maintenance, and you have a contract which is with one specific contractor which will last more than 12 months. If it comes within that definition, then actually the limit is £100, and there's a different consultation. If in fact you're dealing with one-off qualifying works, which could be repairs, it could be repairs, or it could be anything else, you'd still need to consult, and at the moment you need to consult for the whole of the £250 per year on the current case law. So you might find you've got a mixture of long-term qualifying agreements, for example lifts, or a tender process may have been undertaken for garden maintenance, for example. Though obviously not on your flats.
They could also mix up, couldn't they? If you have a maintenance contract with a lift company and then they find a big repair is required, then you have to consult with all the companies again and tender for it.
From a legal point of view, Section 20 is the area that's most in dispute, and it's the area that keeps tribunals very busy. From a leaseholder point of view, you can end up saving yourself quite a bit of money by the landlord not consulting. But there was also a new case that came out last year that actually helps landlords in respect of dispensation. Now, if the landlord gets it wrong, should the leaseholder actually benefit from the landlord's mistake if in fact they've got the benefit of the works that were necessary? And the guidance now seems to be that why should a leaseholder actually have a windfall of not having to pay for these works if the landlord's got it slightly wrong? And there seems to be now more of a the guidance is saying that a landlord is entitled to still charge, although there may be certain penalties given to the landlord. So that was another case that came out last year, and the year before were the busiest time for litigation and really important cases coming out that I've known in my career dealing with tribunal cases. So it's certainly a case of watch this space, particularly on this Francis case, which is the one dealing with £250 per year, or is it £250 per item of qualifying works?
I think there's been an issue with management companies breaking up large repairs into individual items.
Well,
and
they
then
can't
getting
do that
around-
now as a result of this case. So it's quite a concern.
It is, yeah, and there's no easy answer to it.
Excuse me, Sean, can I just ask, is the Phillips Francis case, that's due to be the appeal in April, isn't it?
Yes, that's right.
Oh, okay, right, fine. How do you think it's going to go?
Well, I think it should be overturned. I think the decision's wrong.
Yeah, common sense must prevail there.
Correct, because what's
Yeah.
the point? I mean, it just is ridiculous that you would have to consult for you'd have to consult for everything, because every leaseholder generally would be paying more than £250 per year.
Yeah.
So I think it's wrong. But I did have a housing director ring me from a housing association the other day to say, well, can you guarantee that will happen? I said, there's no guarantee in this life. That's why you have appeal judges. And so no, I can't guarantee it. So he decided then he was not going to take the risk, because if he got it wrong, it was going to cost them £500,000. So they thought, no, we're going to consult on everything at the moment and see how we go. So.
Wanda?
Yeah, if a long-term agreement's been put in place prior to you buying the property,
Yes.
at what point do they then renegotiate when it's due for renewal?
Well, it depends on the length of the term of the contract. You might find that something's been tendered, for example, garden maintenance, and that it's maybe a 3-year contract or it may be 2-year. It really just depends on the individual item or the contract.
So if it was a 3-year, then I moved in and it was 6 months into that 3-year contract.
Yeah, well, there's nothing you could do about it at that stage, because anything would have happened beforehand. If in fact there hasn't been any consultation at all,
Yeah.
and then you want to dispute your service charge because you don't think it's reasonable, then the first thing the tribunal will say is look at, is the landlord entitled under the terms of the lease to actually charge you for this item? Is it within the service charge definition? Has there been consultation historically carried out correctly?
Yeah.
And then if there has, is in fact that service charge cost a reasonable cost? So those are the sort of steps that the tribunal will actually
So
take.
the first thing is to request the evidence of the consultation.
Yeah.
Yeah.
Can I move us on? So,
I was just going to say
Angela,
very quickly,
yeah.
what constitutes consultation?
There's a formal prescribed letters that have to go out with set wording that gives you information in each of the set processes at stages of consultation. It gives you the opportunity, depending on what it is, to put forward your own contractors. If you're dealing with a big estate, if it's say owned by a housing association, then sometimes they have to advertise that through the European procurement rules, in which case you don't have the opportunity to put forward your own contractors. It really depends. There's 4 or 5 different schedules of regulations depending on what sort of contract it is and how big the value of the contract is.
but you can find more information here in the Section 20 lease document provided by the Leasehold Advisory Service, which you can find online, and also you can apply for it. So there's a lot of information.
The lease advisory website is the best tool, and most lawyers will also use it.
Lease Advisory Service, known just as, if you just put lease into Google, you'll get the Leasehold Advisory Service with that document. But I've got a whole load of documents here which
But they
I've
have
already got
precedent
through.
letters and everything as to what a landlord should be doing, or what sort of steps a landlord should be taking in a different sort of case. And it talks about if it's a private landlord, then there's guidance if it's a local authority or a housing association, and then you can actually look at the suggested wording of each stage, and then you can compare that with what information you've been given. So it's a really, really good website.